Hello and welcome, Disability Law Show. Good to have you back again. James Fireman, John Scholes here. Lots of stuff to cover on the show today. We'll get to some emails and other things as well. But first, to reach out, 1-855-821-5900, the toll-free number. help@disabilityrights.ca is the email address. And you want to go to the website, right to the firm website, disabilityrights.ca. Just take the help off and you'll have lots of information there as well. More to get through, but we'll get to that step by step on the show today. 5 ways to improve the likelihood of a successful LTD application. We're going to get to that probably in the next segment, but James, we always start with something that's been cooking for you.
Sure. I'd like to start this show by talking about surveillance and the importance of credibility. So we talk about surveillance from time to time on the TV show and on the radio shows, and generally my advice is don't worry about it. As long as you are being honest with your insurance company and you're being forthright with your doctors, it does not matter if they hire an investigator to tail you around and take video and do whatever they want to do, because if they see you doing anything, it's not beyond what you've told anyone you're able to do. Who cares? If your doctors have told you that you should go swimming once a week and they get footage of you going to the local pool once a week, so what? That's exactly what you've said you're able to do and what your doctors have told you to do. So it really does not matter. But the caveat is it only doesn't matter if you are being honest and forthright with your doctors and with the insurance companies. And the insurance companies love to make you document how you're spending your time. They love to say, okay, you have to fill out this daily log of activities that you're doing. And oftentimes that can be a cue to you that you are going to have an investigator on your tail watching you. Because what they like to do is they like to line up, okay, what did he say he did on this day? And then let's see what the footage shows. And I had a gentleman who called me recently, and he was in very much the same situation. He had gone to a doctor for an assessment and told the doctor that the previous day he hadn't really been out of the house. He'd been up for about 10 minutes, but had mostly spent the day in bed. But sure enough, they had footage of him going around town. I mean, he wasn't doing anything that suggested he was able to work, but it was certainly well beyond what he had reported to the doctor he was able to do. And that is a big problem, even though that isn't proof that he's not disabled, that he doesn't meet the test. What it shows is that his credibility is now in question. What it means is that when he's reporting that he's got a subjective complaint, that the insurer now has a good basis to question whether or not that is a truthful complaint, whether or not he is trying to exaggerate the extent of his disability, because they have him either being dishonest or perhaps not reporting it accurately. When I talked to him about it, what he actually said to me is that, when he talked to the doctor, he really wasn't thinking about that specific day. He was thinking about a different day, and it was just, the incorrect answer. And, when I spoke to him, I actually do believe him. I think it was an honest mistake. But it doesn't really matter once the damage is done. Once that's out there, unless there's a way to really pull back on that, now your credibility has been really injured. The only way around that is if you have absolutely ironclad, clear, objective evidence of your disability. And even then, it can still be really difficult. You think about how you build a claim, and you're going to be relying on medical evidence. You're going to be relying on treating doctors to provide reports talking about your disability. And even when those doctors are doing objective tests to see what your functional abilities are, they will invariably spend some time taking a history with you. And in doing that, they're going to hear what the patient's reported symptoms are. And those are subjective. That's subjective information that the doctor is hearing and absorbing and incorporating into their opinion. And so now all of that medical evidence, where there are your subjective complaints as part of the foundation of the doctor's report, those are now all called into question. They are now of very little value, so it makes it extremely difficult. All of this is a cautionary tale to say, when you are speaking with your insurer, when you're speaking with your doctors, you have to be honest. You have to be forthright. You can't lie about what your functional abilities are. And if you do, more often than not, you're going to get busted on it, and that's going to be a big problem for you.
Is it often the case where the person being insured and has been asked to provide this daily information, they're not so much being malicious or being sneaky, they just think, oh yeah, I just went out and grabbed a bag of milk and came home. Well, that's not really what you told us, but that's what he did that day. They don't think they're really doing anything wrong. We often talk about the fact that sometimes you're on the phone with the insurance company and they'll say, how are you today? I'm great. That little term, I'm great, is very colloquial for you and I, but that could have detrimental effect on your claim.
Sure.
Something like that?
That type of thing doesn't bother me so much. The I'm okay or I'm doing great or what have you.
Right.
I think that can be pretty easily explained if you look at it with any common sense whatsoever. But it's more about what you report to your doctors or even in those log notes that they ask you to file. If that is contradicted by surveillance, then that's going to be a problem. And so I would urge people to make sure that they take those things seriously, that they don't just sort of wait till the end of the week and then go back and say, okay, what did I do this day? Well, I probably didn't do anything, and just write you did nothing or pretend. Because if they have hired someone, and they may have, then you're going to be in some hot water. Your credibility is going to come into question. And the way I think about it is when your credibility comes into question, that's like a disease, and that's going to infect your entire claim. Even if it's only in this one little area, all of a sudden, everything that you say, everything that relies on someone believing what you have to say is now going to come into question. That infects your entire claim. So be very careful about what you are saying and make sure that you are being forthright when you're talking to insurers or when you're talking to doctors.
I think that word surveillance really still scares people. So talk about that for a second. The insurance company now hires someone or a team to surveil you and follow you around. A, is it expensive? And B, if it is expensive, are they going to try to extract every bit of good they can out of that because they paid good money for it?
Well, first of all, I want to dial this back a little bit because I don't want anybody being out there scared that all of a sudden there's going to be this team of investigators that's going to swarm upon them and they're going to be followed for the rest of their lives. Surveillance is still the exception. It is still a rare case where I find that the insurance company has actually hired an investigator. So just because you have made a claim or even been approved for long-term disability benefits does not mean it should be your expectation all of a sudden that there's going to be someone that's going to be following you. But it does happen, and it's not so infrequent that it isn't worth talking about, hence the start of this show. Right. And when they do pay money for an investigator to follow you around, they're going to be spending good money. They're going to be spending $5,000, $10,000 at a minimum in order to get that information. And if they're spending money out of pocket, you better believe that they're doing it because they think they're going to get that money back. And the only way they're going to get that money back is if it gives them information that justifies cutting off your benefits. And so they're going to go through that as carefully as possible, and they're going to find anything that they can to justify cutting off your benefits or denying your claim, because now they've spent the money and they have to justify having spent that money. So how do they do that? They'll find anything they can. They will take things out of context all the time. So just because your insurance company has conducted surveillance and said, oh, well, we found things that were inconsistent, that doesn't mean that you have to take their word for it. It doesn't mean that they're correct. And if they won't provide you with that surveillance and they've cut off your benefits, then bring a legal claim. And once you do, I'm going to get access to that entire surveillance file. I'm going to see everything that's in the report, and I'm going to know exactly what it is that they read in that report that led them to that conclusion. And more often than not, it's nothing. More often than not, it is completely out of context and not even close to a rational justification for terminating benefits. So don't take their word for it just because they say it shows something. If it doesn't seem right to you, if it doesn't pass the smell test, if you think, well, that just can't be true, I didn't do that, then don't take their word for it. Call me, and I'm happy to give you a free consultation. And if we start a claim, I'm going to get that entire surveillance file.
Which is interesting, because that makes me think now that once you have the file, if they've got 75 hours of surveillance on somebody and they pull a little 2-minute nugget, which shows something, maybe nothing significant, well, doesn't that give you 74 hours to your benefit saying, guys, this yielded very little?
John, I feel like you've heard this before.
Maybe.
No, you're quite right. And so the first thing that I'm going to do when I get a surveillance file is I'm going to look at, well, how long did the surveillance last for? How many days, how many hours on each day? And out of that 50 hours, 60 hours, 70, 80 hours of surveillance, how much did they find that my client actually left the house and did anything? And if they found 15 minutes worth of surveillance over 50, 60 hours, that says something. Mm-hmm. You know, someone who isn't leaving their house, 6 out of 7 days, and the one day they leave their house, it's to, do grocery shopping, fill up the tank of gas, and come back home. And invariably, I don't know why this is, but invariably go through the Tim Hortons drive-thru. Everyone seems to do that on surveillance. If that's all you're doing on this surveillance, if that's all that it shows, then the surveillance is really proving my case for me. It is showing that this person is disabled because they're not doing anything.
That's what I'm thinking. Pocketemploymentlawyer.ca. That's the next website I want to throw at you. Later, we're going to get to that. But also, the ways for you to answer questions, mydisabilityquestions.com. You're thinking, why do you have Pocket Employment Lawyer on this show? Because, and James will tell you, there's a big section on disability law. It's not so much questions, it's about learning. And you can go there anytime. Pocketemploymentlawyer.ca. Completely free, completely anonymous. So take advantage of it, use it, and always learn more of what you get on the show, right? We got time for an email before we break. James, help@disabilityrights.ca. By the way, is the email address. Drew, this time, first one for this show, says, I've been on LTD for 4 years due to aggressive high-risk prostate cancer. My treatments have resulted in continued low energy, brain fog, and memory issues. My doctors say I'm not ready to return to work, but my insurance adjuster wants me to attend a virtual assessment. Do I have to agree with this?
Well, I mean, you don't have to agree with it, but you do have to go, unfortunately. Right. Insurers, they have a right to evaluate your claim. And included in that is their entitlement to have any reasonable assessments. So reasonableness means that they can't, have you assess every week. And the person that's doing the assessment has to be a qualified expert in whatever field is relevant for your particular case. But my issue with it isn't so much that the insurers have this right, it's how they use this right. And in my view, it is way overused, John. So yes, the insurers can have their own people look at you and their experts can comment on the case. But what we know is that at the end of the day, if this case ever were in front of a judge, 99 times out of 100, the judge is going to take the opinion of the treating doctor over anyone who is hired to give an assessment and who sees the person for maybe an hour or so and is paid by someone who has a particular interest in the case. That's going to happen in virtually all cases. Not all the time. There are exceptions. There are cases where a treating doctor might be found to be an advocate, or perhaps the defense expert might be the leading expert in this particular field, and just by that is going to be afforded a certain amount of weight for their opinion. But those exceptions aside, in almost all cases, a judge who would see this at the end of the day is going to value the opinion of the treating doctor over any expert that might be hired. And knowing that, insurers still are going to engage these experts, these so-called experts, all the time. And the reason is obvious. It's just so there is a superficial justification for denying a claim or for cutting it off. So they can say, yeah, well, we sent you to our expert and they said that you're not disabled and therefore we're entitled to do that. Well, yeah, okay, they're papering the file, but they know very well at the end of the day that opinion isn't going to hold up, and yet they still do it. And they do it because they know most people won't challenge it.
And in Drew's case, it said virtual assessment. Does that make it stronger for his case?
I don't want to come down too hard on that. I don't know what the situation is. And obviously with the pandemic, there are some limitations on what can and can't be done. So it's not necessarily inappropriate that it's virtual. Obviously, in person is preferred. But certainly I've counseled my own clients that if you can't go in person, then do it virtually. And so if I'm going to say that to my clients, I can't be too critical of insurers that are doing the same thing. But yeah, it's probably better if it's in person, but that in and of itself, to me, doesn't really move the needle all that much one way or the other.
All right, short break. 5 ways to improve an LTD application. That is coming up, but we'll do that after the break on the other side. 1-855-821-5900 and help@disabilityrights.ca. Stick around, coming right back. People think you should go to the government to get severance pay. Employmentlawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at employmentlawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. Employmentlawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at employmentlawyer.ca. All right, welcome back, Disability Law Show. Good to have you again this week. James Fireman, John Scholes. We're going to talk about 5 ways to improve the likelihood of success of an LTD application. Before that, way to reach out, 1-855-821-5900, disabilityrights.ca. Samfiru, Tumarkin, the most positively reviewed disability law firm across this country. How about that? Okay, number one, James, clear support from your treatment providers, including doctors.
So this is much more about what your doctors are saying than anything that you can do particularly.
Okay.
And I'm always, as a lawyer, very hesitant to talk to a doctor on my own and say, oh, it needs to say this or it needs to say that. It is critical that whatever opinion is being provided by a doctor is their own opinion. On the other hand, when a doctor approaches me and says, listen, this is my opinion on this particular patient, but the insurer doesn't seem to be getting it, how can I express that opinion in a way that is going to be more effective? And there are lots of things that I can discuss with the doctor in that context. And just as an aside, if you're watching this show as a medical practitioner, as a doctor, any treatment provider, and you have a patient who is within the LTD process, and you want advice on how you might go about that, please call. Feel free to call. We're happy to talk to any treatment providers that need advice on how they might go about the process. You don't need to reveal any confidential information about your clients. We're happy to talk to you. It's completely free. But generally speaking, what is going to be more effective from your treatment providers is if in their notes they are addressing the critical issue in disability insurance, which is your ability to work. So it's important, of course, that they understand what your job is and what it requires, and then relate that to your medical condition and how you may or may not be able to function in that environment. If that's in there, that is really, really helpful and makes it very difficult for an insurance company to say that you don't have sufficient medical evidence.
Improving the likelihood of a successful LTD application. Number 2 point is this: aggressively pursuing assessment of your disability.
Yeah, so this is critical, not just from a legal perspective, but also from a medical perspective. And we're talking here mostly about people who have conditions that haven't been yet diagnosed. So if you don't know what is causing your symptoms, it's critical that you are aggressively taking steps in order to figure out what's going on, what's behind the symptoms that are preventing you from being able to work. Because even though the LTD process doesn't require you to have a diagnosis, if you don't have a diagnosis, the insurer is going to treat your case differently. Most of the time, if you don't have a diagnosis, they will deny you, even though they shouldn't be doing that if your symptoms are preventing you from working. If you don't have a diagnosis, they will typically deny your claim. But that doesn't mean they're going to be justified in doing it. And if you want to be able to show that you have a legitimate disability, one way to do that is to be aggressive in getting assessments for your condition, is to ask for referrals to specialists who might be able to assess what is going on and what can be done in terms of treatment. And if you've done that, if you've seen 3 or 4 different specialists in different fields and they've all run the battery of tests, even if all of those tests come back negative, even if they still haven't found what is underlying your condition, you have still done everything possible and you've shown that you are taking every step you can in order to figure out what's going on. And that is really good evidence in support of an ongoing disability.
The third thing you want to exercise is this is a big one: full compliance with treatment recommendation.
Again, this is also really good advice from a medical perspective, not just a legal perspective. But from the the legal perspective, the insurer, even if you are disabled, the insurance company is entitled to stop paying your benefits if you're not compliant with recommended treatment. And so there might be a dispute about what's recommended and what isn't. It may well be that they send you for an assessment and their doctor says that you should be getting X, Y, and Z, and your doctor says no, it should actually be A, B, and C. Listen to your own doctor in those circumstances, especially if your own doctor is saying that the recommendations of the insurer's expert is going to actually be harmful to you. But what you should be doing is taking steps to ensure that any recommended treatment by your own doctors is being followed as far as it possibly can. Now, that doesn't mean that if your doctor prescribes a medication and you have a bad reaction to it, that you have to finish that medication. Of course not. If you're prescribed something, you should absolutely fill that prescription and try the medication. But if it doesn't work for you, if you have an adverse reaction, or if it's just not being effective for whatever reason, report to your doctor and have your doctor indicate in the file that this medication was stopped because of the adverse reaction or ineffectiveness, whatever the case may be, so that there isn't an avenue for the insurer to say, oh, well, you didn't follow that treatment recommendation. You had, prescriptions for these two medications that you never got filled. You were advised to go see this therapist or this counselor, and you never did that. If you give the insurer that kind of ammunition, they're going to use it, and it's not hard for them to do it.
Things you need to do to hopefully ensure a likelihood of a successful LTD application. Number 4 is this: ensure the insurance company has all the relevant medical records.
Sure. I mean, this is really straightforward. This is just about ensuring that your insurance company knows all treatment providers, not just your family physician, but any specialists that you're seeing, any physiotherapists, counselors, what have you, naturopaths, whoever's providing you with treatment. You want to make sure that your insurer is, 1, aware of it, and 2, has access to their entire file, so that they can't say that you haven't seen anyone, that you don't have sufficient medical evidence to support your claim. It's also important to make sure that that's up to date. So if you have any sense that the insurer doesn't have the most recent files, or that they might be trying to get their house in order to try and cut off or deny your claim, I would put in writing, I'd send an email to your claims handler saying, I just wanted to check in and see if you have the updated files from all of my treatment providers. If not, please let me know. I'm happy to assist in getting those for you. And then it's simply a matter of contacting your treatment providers and lighting a fire under them to make sure that they send those treatment records over.
Even with that, before I move on to number 5, what is the likelihood of insurance companies saying, nope, need more, nope, need more, nope, need more? You're like, come on.
It happens all the time. It really depends on the case. It depends on what kind of disability you're dealing with.
Number 5 is this. I find this really interesting. Reduce all communication with the insurer to writing. So,
yeah, that's critical. So I would, in every case, ask your claims handler if they will communicate with you in writing. Some will, some won't. If they won't limit their communication to you in writing, if they insist on calling you, so be it. What you do whenever they call is you say, please hold on just a moment, go get a pad of paper and a pen, or get to your computer, and just take detailed notes of the substance of that call. As soon as the call is over, put those notes into an email and send that to the claims handler so that there's a contemporaneous record of everything that was said. This way, the claims handler can't interpret what happened in their own way and be confident that you're never going to be able to dispute that. You've put your interpretation of that conversation on the record, and if they have an issue with that, if they think anything you've said is incorrect, then now they have to respond to that and say, oh no, that's not correct. I didn't say that. That's not what I meant. What I actually meant is this. And that's really important because insurers love to call their claimants and put things in a way that suggests one thing even though it's actually something else, and leave someone with the impression, for example, that their benefits are only for 2 years, when it's really that the test changes after 2 years. They'll say things in a way that suggests that you only have a claim for 2 years and leave you with that impression. If they do that, you put that in an email. You say, you told me in our call that I only have benefits for 2 years. When they get that email, they're going to now be in a position where they have to correct that. They have to say, well, no, it's not that you only get benefits for 2 years, it's that the test changes after 2 years. So everything that you say in that call, reduce it to writing, send it by email.
I mentioned mydisabilityquestions.com. We're going to get to a question from that after the break. It's not only for the TV show. You can go there anytime, mydisabilityquestions.com. That is on the way, and the phone call anytime, 1-855-821-5900. Disability Law Show continues. Stick around. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. A few minutes to go, so let's get at it. MyDisabilityQuestions.com. That's where we're going to go right now. VJ, this is his question for you. James says, I am waiting for surgery on both hands to help with my carpal tunnel. My surgeries have been delayed and pushed back due to COVID-19, and unfortunately, my doctors say I can't return to work until I am healed after surgery. The insurance company wants me to try another job and says my benefits will end soon. I've been at this job for over 10 years and I'm working towards my pension. What can I do?
Well, okay, listen, it really depends on where VJ is in the process. If he's in the own occupation period during the first 2 years that you're entitled to benefits, then he's going to be entitled to his benefits for sure if he can't go back to his old job. Assuming he's beyond that 2-year period, then it goes to the any occupation test. Do you have a disability that prevents you from doing any occupation you're qualified for by training, education, or experience? Just because you might be able to do some sedentary job doesn't mean that you're going to qualify. It doesn't mean that you're going to be able to earn a commensurate income. But there are also other factors that you really have to think about. I mean, VJ's got, severe carpal tunnel issues that are requiring surgery. So my guess is, he's probably not going to be sitting at a computer trading Bitcoin. He's obviously got some issues with his functional abilities. So I don't know if they're really going to be able to show that there's anything that he's qualified to be able to do, especially when you've got a surgery looming on the horizon, right? When you're talking about someone who is facing a surgery, yeah, there can be justifications for an insurance company to say that you still can do some work, but when you're talking about a surgery, especially if it's carpal tunnel in the wrist, that's really impacting your ability to sit at a desk and use a keyboard or what have you, it makes it very difficult for the insurer if you challenge them on it. And at the end of the day, they're going to see that. Surgery is an objective thing. Right? And when you're scheduled for surgery, that is a medical expert that is saying you have a really significant issue that requires us to open you up and fix it. And if it's that severe, and carpal tunnel surgery is a significant procedure. If it's that severe, then you're going to have a really good claim. So I would really question what basis the insurer is denying in this particular case. And I think, VJ certainly has a good basis for a claim based on what I understand from his email.
Going to get Olivia in here quickly with her email. Here you go. James says the insurance company said that they denied my LTD claim because I work. Prior to applying, they didn't care about my reason for the application. I was barely able to function properly due to severe pain and had to wear a corset to maintain stability. The denial occurred despite reams of documents from my doctors. Should I appeal?
Olivia, no, don't appeal. You have to think about why the appeal is there. If you look in your policy, you're not going to see any reference to appeals there. The insurance company offers an appeal because they want to maintain control over the process. And so when they send you a letter that says your benefits are denied or we're cutting off your benefits, they want to direct your frustration down a particular path. And the path they want to direct you down is the appeal route because they control it. They invented it. It's not part of the policy. It's not required by law. They've just created this process out of thin air for the sole purpose of maintaining control over you and your claim. You don't want to give them control if you don't have to. If they're paying your benefits, so be it. As long as they're doing what they're supposed to be doing, okay, they can maintain control over the process. But as soon as they stop doing that, there is no reason to continue to give them that control. How do you take it away from them? You do that by talking to a lawyer and bringing a legal claim. As soon as you start a legal claim, the insurance company can no longer control what happens. They are not the final arbiter of whether or not you're disabled. If they are not reasonable, they wind up in front of a judge, and they have absolutely no interest in doing that. And when you force them to face that potential path, all of a sudden, they become very reasonable. They come to the table, and you get what you're entitled to.
If you want to reach out anytime, something has piqued your interest, or you have more questions anytime, a bunch of different ways you can do it, right? First of all, the phone call, 1-855-821-5900. The email address we use, like Olivia, help@disabilityrights.ca, mydisabilityquestions.com, free and anonymous anytime as well. Reach out to James and his crew at disabilityrights.ca as well. That is the firm website. We'll catch you next time. Disability Law Show. Thank you so much for hanging in.